Today we'll be seeing intellectual property LP 2.0, how to identify IP issues in everyday legal practice. As a young lawyer, imagine you're going to have your first client this week. What brief would you like to receive first? You have seen one person thought, IP, that's excellent. Welcome to my world. Can I see more? A young woman walks into your office. It is your first day of practice. Remember, some of you may not be lucky to find a law firm to engage you immediately. Some may already be working in a law firm. She's confident about what she has, and she's confident she walks into a law firm. So you're supposed to have all the answers, right? Nobody walk into your office to tell you, I have an intellectual property case. Because the truth is this, most people out there don't even know what is intellectual property. And some don't understand the importance of intellectual property. So cases related to intellectual property normally come as a story. It will come as a problem. I have a business name. Someone copied my logo. I have written a book. I have created a mobile app. I designed a unique product or a unique product package. I invented a small machine, a secret recipe, and I've just signed someone to build my website. So I want to see your reaction. Who can identify, or in your own little way, try to identify the issues that have been raised? We're having a conversation. She has just told you her problems. I want to see your responses. Let's know from there. Many issues have been raised there. So many issues. At least identify one or two. What are the issues you can see? The IP related issues, all of them. There's an element of IP. When I say IP issue, what kind of IP can you find in them? Then tell us what are the questions going on in your head in terms of if you're seeing a trademark, which angle of that aspect has a trademark in it? If you're seeing copyright, what element of the scenario has copyright in it? If you're seeing some other aspect of law other than trademark, let's also feel. Yes, I can see some people say trademark. It looks like I have a pro in the room. I'm not talking to you, I'm talking to the young lawyers. I don't want to see your message, you know yourself, please. Don't send me anything here. I don't want to see your messages. I'm talking to the young lawyers in the room. Please, let's go. Yes, I've seen somebody tell me trademark. So what angle of this conversation is a trademark? Please, our class is going to be practical. If you think you don't know intellectual property and you want to be a part of the theoretical aspect of intellectual property, we can accommodate you. Have another firm for undergraduates. Maybe we start from there for you. But I want to believe everyone that starts in law school must have heard about intellectual property. And since joining the forum, that's why when I put a survey, I expect us to participate. So if it's one person telling me it's trademark, it means I have to run and then step it down a little bit. This is just to test your knowledge of intellectual property. Please take it to my next slide. Thank you. Let's go. This is one framework I've designed here at the academy. I will call it the IP Sporting Framework. This is what it helps us to do. If I wear your shoes and somebody walks into my office, all those package scenarios in one problem, I'm not going to rush to start saying, oh, I see a trademark, I see this, I see that. Run off to start saying, I'm going to court to go and sue. Somebody stole my client's IP. I mentioned something that's in that class. You need to first confirm who owns that intellectual property. Did you even bet it? Because so many people say, I have an idea. My neighbor stole the idea that I have. And then the question becomes, is an idea protectable as an IP? The answer is obviously no. But so many people don't know this, including lawyers. And so once somebody says, my idea was stolen, you're already ready to go to court to start suing. Yes, I see trade secrets. Absolutely. I see trade secrets. Trade secrets. That's beautiful. And so we don't just run off. The question for us at DVIPC begins with move. Remember, if you are not a party to a lawsuit, you dare not go to court to say you want to sue, right? The matter will be thrown out of court, of course. And so that's what happens with your intellectual property. So when you have a scenario, someone to come to you with all those legal jargons, it simply means they're ready to go to court. It simply means they need your expertise to show them the way to go. So the first question for us here is, who owns the IP and how do we determine who owns the IP? I just mentioned something like an idea does not qualify. So if this person that came to you is just talking about ideas in their head that's not been implemented into a tangible product, this was part of the details from last week. We said something like, when the person does not have an intellectual property, so don't bother discussing. Don't waste your time. There's nothing on the table for you to spend your energy on. But this scenario for this week is saying she has a branding, she has logo, she has contracted somebody to build her website. So you see a lot of things. For the few people who were part of the first class, you understand we said something like, before you run here at DVIPC Academy, it's first who created what was created. That will be the next one we'll dive into. So we're asking what was created, what exactly has been created. So she says something about she has a logo, so she has told you the what of what she created. She owns a business name, right? And then she tells you about maybe the book she has written, and then she's about to build a website, and she has contracted somebody to build her website. So in that scenario of building a website, she has commissioned someone. You begin to think about work of commission. I'm sure all of you are familiar with that. So who is going to own what? To what extent is she going to benefit from the work that is being created for her? So when we look at what exactly has been created? Is it an idea, like I just mentioned? If it's an idea, there's nothing on the table. Except the scenario changes. You then say, I have an idea and I'm trying to protect my idea. Then you can listen to the person. But if it's a situation where the person is ready to go to court to sue, there's a conflict, and the person is simply saying, I have an idea, which means this idea has not been converted into a tangible good. Okay? It has not been converted to something you can feel, like the person wrote a book, like the person created a business, like the person, invented something. Then there's nothing on the table to have that conversation around. It's a brand. The person has created a trademark called a brand, a logo. It's a book. We are looking at copyright. Software will also come under copyright. If it's a machine, that is an invention. That's patent. If it's a design, that's industrial design protection. If it's a formula, that's trade secret. Like somebody rightly pointed out, that's trade secret. If it's performance, that's performance right under copyright as well. So by the time we determine who created the words, do you have one person creating? Do you have more than one person creating? Is it a company creating? Are you under an employment with this company? Is it an hire for portraying work of commission? Is it something you're contracted to do? What is the agreement on the table? Is this something you did outside the scope of your employment? All those things will determine who created, whether it is you or whoever employed you that created. That's number one. Whether it is you or the person that hired you by reason of work of commission that also created. So having discussed who, we now discuss what was created. This woman has told us she has established a business. So she has a brand name. She has a logo as well. She has created a logo. Perhaps she designed the logo herself. Perhaps she contracted someone to design the logo and much more. Those are questions to now be asked. Whether it was her who designed the logo, whether the design of the product package she has, did she do it by herself? Did she contract somebody to do it? So we want to find out all those things. And if she contracted somebody to do it, then you can then say, okay, we have an industrial design somewhere. We have trademark on the one side, and the mobile app as well. So all those things will now be coming together. If you're working by yourself, no joint authorship and all that, so it's just you we are looking at. So I haven't identified who, so you're sure she's the only person on the table. And then you down look into all the things she claims she has created. Make sure that maybe they are not stolen work. So all those should be going on in your head. Is it her work? Did she steal it from somewhere? Then the next thing we move to is then when. If we have discussed who, when was this created? Was it created before the employment? When I got to the IP clause, it said something like everything a person may have created in time past before the employment is going to belong to this company. Can I see your comments? Does that sound okay? Should you want to take up an employment and part of the contract of service is saying, yeah, somebody raise their hand. Emmanuel, please, if you can unmute and talk to us. Do you think there's fairness in that? Do you think that's a good clause? Because sometimes it comes as an agreement to, please let me review this agreement. So all this, so please let's hear you. If you want to.
No, I don't think that is applicable because invention the person have already created before joining the company. My view is that invention the person have created before joining the company should not be included in the contract as the company's own.
Good. Thank you for that. Deborah, do you have a different opinion? Let's hear you. Oh, she left the call. Perhaps the network is bad. All right, so it's totally no. So sometimes IP issues will just come like a contract of employment. And just that one page that has IP clause is just what we need to review, and you see some red flags and tell the person, oh no, it doesn't make sense to say something somebody created, maybe he created a mobile phone. Somebody is telling you, before we give you this job, they'll pay you 200,000 naira. You first give us the value of this mobile phone. You are going to see this work. Another clause says, even after you leave the office, this your mobile phone still belongs to them. So for me, that's a red flag. And I pointed the person's attention to it, that before you sign, you need to make some adjustments. Otherwise, this is what and what you stand to risk. Although the person is yet to become an inventor, so the person is less worried. The person is just like, no, they bring the job first. That's Niger for you. But later on, no, they don't say if they will not talk. Like I said, this person is family. If it is before the employment, that business has no reason asking you for your intellectual property. If it is after employment, the question is, during the employment, what were the terms of employment? Were you employed to create something for the company? There's somebody who works in a company, is an IT company, okay? You know, we're in the age of technology, so many apps are out there and what have you. And so this person is just a doorkeeper or maybe a receptionist. But somehow, because she grew up seeing her grandfather build things that relate to her. And so this company is designing an app, and the team are having issue concluding the app, making it to work. And somehow she has this know-how she inherited from her dad, or she observed from her grandfather, or from whoever that she grew up with. And so she brings it to the table. So the question is, that person's contribution, how should it be valued if the person is not employed as part of the IT team, who were originally employed to create the app? Yes. Emmanuel, let's hear from you.
The person's efforts to be acknowledged while registering the IP.
Okay, Emmanuel says this person should be acknowledged while registering the rights. All right, let me quickly discuss that. That's why I said, as many scenarios that come to my head, I would like to top them up, and I need your interaction, but to take us to one or two things that are perhaps not on the slide. And so this scenario that I just stated is a beautiful way of discussing another angle to this conversation. So when somebody is originally employed to do something else within an organization, then the question is, what is within the scope of the employment or service contracts? If you are not originally employed to create an app, it's not within your jurisdiction, more or less. It simply means you should be acknowledged, and not acknowledged for mouth. You should get something out of it. So assuming after they created this app, the company is selling by way of assignment or their license, and so they're getting royalties. You should be able to say, okay, we can give you 5% or can give you 2% on top of your salary, 2% of whatever deal you get from the assignment or license. I hope you understand it. So each time royalty is paid, they're giving you 2% of the royalty you get on top of your salary. And it's going to be in perpetuity as long as the assignment lasts. So if the assignment is such that will last for 10 years, or the app is going to remain relevant for the next 20, 30 years, as long as that lasts, that 20, 30 years, you continue to get that percentage. But if I was employed to do that IT-related work, then I'm not entitled. I am not. It is part of my contract of service to build an app. And so it is before employment, you have looked at it, it is after employment. The question is, during the course of employment, something else can happen. I was employed to build an app. But for some reason, I decide to build an app in my house, different from the kind of apps you build in my office. And I didn't do it within my workstation. I didn't do it within the work hours. I didn't use the office resources. It becomes dicey. Who owns what has been created? Can I lay claims to what has been created? Can I say it is mine? Or would it be a case of 50-50? So when we have the total, all the facts on the table, it guides us, who should inherit what, or rather, who should claim the rights on that intellectual property. Maybe they are going to share the rights, or maybe it's just one person being the creator who created it. I hope you understand that, so that you can also have that scenario. If it is a case of maybe work for hire or a work in a commission to do, it will also depend. Because based on the Nigerian copyright law, for instance, if you are commissioned to do a work, then the work belongs to the commissioner. That's the person who owns the rights. So it's a kind of work of employment, right? So if the person who employs you, like a photography business now, it's your wedding day, and you call it photographer. You commission the photographer. So always pay attention, because right now even photographers are getting wiser because they now know the copyright vests in them. But I like the way the Copyright Act puts it. It's a work of commission, then it belongs to the person who commissioned you. But for instance, you are not the wedding, you are not even a real wedding guest, like not part of the, you're just a passerby, or even you're just a random wedding guest. And this photographer jumps in randomly from nowhere. He wasn't contracted to cover the wedding. And he takes your picture. And the next thing you see yourself is maybe on social media. That's a different scenario. Because one, the photographer that took the picture and you yourself, if you don't have a relationship in terms of a contractual relationship, it's just a random photographer. He creates the picture. So ideally, you'd be saying the copyright, okay, let me hear from you guys. What do you think in that second scenario? Because there are two scenarios painted now. One is the person who owns the occasion, maybe the wedding bride that invited a photographer to cover the events. So it's a work of commission. But the other aspect, I want to hear your contribution. The aspect about a random photographer. You know, it is in Lagos or Abuja. They're having a wedding. There's so many photographers who are not invited, who join body and come for the party, right? And they'll take pictures, spread the pictures on the floor. Even during your call to buy, you saw perhaps, I really don't know, photographers like that. They spread pictures on the floor and then impose it on people to come and pay to collect their own picture. If you don't pay them, they say they're carrying the pictures home to go and destroy it. I'm sure you have encountered such. So one of those photographers is the one who has clicked the camera now, takes your picture, posts it online, or you will see yourself somewhere tomorrow, maybe on a billboard or something. Let's react, please. Who owns the intellectual property? Or what are the issues in this scenario? Can I hear your contribution? Remember, when you contribute, you also to remember something else to discuss. Who can we say owns the copyright in that work? What other issues can you see in that scenario other than copyright? Since I've mentioned copyright. Any other issues? A scenario like that, you have two issues especially. You have that issue on copyright, which will normally belong to the photographer. And the issue is, did you give consent? That aspect now takes us to what we call image rights, or some people say personality rights. So it becomes a conflict of law. Who owns what? I didn't give consent for my picture to be taken. I remember in this age of data protection rights, I do have a case to say, I'm going to sue you. Why did you take my pictures? And then the photographer has a right to protect him as a creator, who will then say, I'm trying to put food on the table. So it's part of my work. I was just passing randomly and took a picture on the streets of Lagos, and somehow your face entered it. And then you now say scenes are fair, because you have a rule in copyright that says scenes are fair. So it becomes a justification why it is. So we have conflicts of law. So depending on the full scenario, you don't know where to balance the equation. But these are issues that should be popping up in your head. So sometimes you might have a scenario, it's not just IP, there are other rights or laws that are closely related to IP now, especially data protection, personality right, image right, which you don't even have a legal document like an act or law backing them properly in Nigeria. Before disclosure, now the element of this disclosure is dicey in intellectual property. So disclosure, remember we found something like trade secrets. Another angle is patents. There's that element of disclosure that you can't just disclose. So if before disclosure you didn't protect, it becomes a concern. Even if you don't disclose and you build a machine, our brothers in Aba, you know what they do there, right? They have that technical brain. They can dismantle and couple back and then put in China. They uncouple and couple it back if it's coming from US and tell you made in China. And then they export down to us. So you have situations like that. Can I move to my next slide? Because timing can determine ownership and rights in intellectual property. Please let's move to the next slide. And so here we have ownership. Let's quickly talk about it. Recall that we have discussed who created what. Now this is where it becomes very interesting. The who, is there an individual, like this your client has come to listen to today? Is it an individual? Is there somebody else who contributed maybe 50%, 20, 10% during the creation of the work? Like in the scenario we painted about receptionist who assisted in concluding the app creation. Maybe that little know-how she brought in was what saved the firm from embarrassment of maybe over 1 year or 2 years. So you see that the information she brings to the table is worth the value if she decides to negotiate with the company. So you begin to be like, is it an individual? It is an individual, is less complicated. If there are 2, 3, or 4 people, like I recently created a copyright list of people's names. And so I asked all those people, what are their roles? She tells me they contributed because they work in the same place. So it's like a teammate, that team relationship. And so after everybody has donated or contributed their knowledge, she then wants it to be in her name and one other person's name. So I began to dig deep to then say, okay, if these are all the creators, because before I let a client know the reason I'm asking for some information, I get the information out of the client. And there's a reason you do that. Because in IP, if you protect something that ideally should belong to more than one person in the name of one person, anytime it is disclosed, that right can be stripped off that person. That's the general rule in IP. You get it? I'll take it again. If, for instance, 2, 3 people created an intellectual property right, such as maybe a patent, and you don't disclose that information, you are run off with that right all by yourself. You risk eventually being a part of the deal. I hope you guys are getting it. So because now you have gone ahead to claim what does not belong to you, to claim it to be just yours alone. As practitioners, we want to stand in the middle. So in as much as this is the person that brought the brief, you don't treat IP like every other form of law, where your interest is like intellectual land law, for instance. We use a lot of land-related, because last week we had to differentiate between the normal property, tangible property, and IP as intangible property. I'll look at a lot of those differences, and I think it was a beautiful session. And so one of the things we found that when it comes to land, you want to favor your client who has brought the deal to you, knowing that is the one paying you, right? But when it comes to IP, the best way you can protect that client who brought the deal is to make sure everybody involved in the deal, they are listed on the table. That's the best protection you can do. So you can't be selfish when it comes to IP. You need to strike a balance. Make sure you are protecting the person and at the same time the general public. Because the number one founding principle of intellectual property lies on 2 things. Number one, IP is meant to give rights of ownership, exclusivity rights to the person who has created it, to the best of the person's way of wanting to enjoy their rights. Nobody should disturb me. This is my territory. This is my book. I want to read from it. Then IP then strikes a balance. In as much as you know it is your book, I'm using a book for instance. We are going to strip you some elements of this right. So the reason we are doing this is, for instance, let the people who are blind to also read this your book free of charge. And so we'll take this right and give it to somebody who is going to convert it into a version that people who are blind can be able to reach without paying you. Nobody's giving you compensation. Nobody's paying you royalty. You get it? Another angle to it is, as a student, you have a right to go and copy a page or 2 from that book and use it. And the best you can do is to acknowledge the person, otherwise it's plagiarism. You understand that? So IP strikes the balance between you enjoying that right and having a little bit of it reserved to the public. So it strikes that balance. That's number one reason. Number 2, so that at the end of the day, you are not stripped of your rights, so that you continue to be a part of people who are going to enjoy that right. So if there are 10 people, you must be able to disclose. So before a client knows why, make sure you get that information out of the client. How many people were involved in this? Was it only you? Were there 10? Were there 20? After you have gotten all their names, you then begin to explain to the client, this is why I was asking. So don't try to play smart like we have in other aspects of the law, where you run up with one client's name and go to court and exclude every other person and you think you're being a smart lawyer. Now, in intellectual property, value lies in the person who has created. Value lies in the person who created the work. Is it the company that created it? Was it work created during a work relationship? Then the right lies in the company. If it's your personal work, it lies in you. In fact, copyright will tell us that there is that element of first rights. The person that owns the first right on any copyrightable work is the author of the work, and it's not negotiable. You are the first owner of the rights. Then after it has been established that you are the first owner, you can now choose to alienate that right to somebody else. Only after it has been established that you are the author of the work. And the reason is this: you may be an author, but not be the owner. So there are two different things under copyright. And in every other form of IP, if it's patent, you might say you may be the real inventor, but you are not the statutory inventor. In trademark, we'll say you are the proprietor, but you are not the owner. Are you getting the point? So you may be a proprietor of a trademark, or you own a business, and then tomorrow you decide to sell it. The moment you assign to somebody else, then you stop being the what? Owner, and perhaps also the proprietor of that trademark. So that's how it works. So you have value. Value lies in the person that owns, not in the person that created. I hope you guys are getting it. If it's a land now, for instance, the person who owns it is the person that owns the land. And we know how we say it in law, that either what owns the land, owns what is on the land. In IP is not justifiable. You may be the author of work and not necessarily be the owner of work. You may also be the author of work and be a joint owner of work, meaning you authored it, but you have decided to share your rights maybe into two, may not be equal, with another person. So there are 2-3 people benefiting from its ownership. So depending on the scenario, so you need to open your mind to understanding all the streets in IP. It can be very tricky, but if you consistently come to class, there's no how you not build confidence in yourself. And no matter what comes to you as a brief, you know which angle to take it from. And so when discussing value, we want to say, what is the value in what was created? It is a brand name, for instance. Recall that we have franchise deals. When we were growing up, we used to see a lot of Mr. Biggs everywhere. And then we didn't understand it back then because nobody taught us intellectual property. And someone like me assumed that this Mr. Biggs was very rich. He's everywhere, he's everywhere, he's everywhere. One person owns all this business. Sometimes I'm thinking to myself, how does he manage all this chain of businesses and what have you? So coming to understand what intellectual property is, I then begin to understand it was just franchise. And some of you are aware that some ShopRites have closed down because they've gone back to their country. But you see some still running. And so it becomes a question for a child. I heard my children discussing sometime last week when we went out. I think they're discussing ShopRite has closed. My daughter said, no, the one in Jabi Lake is still there. Is this one that has closed, the one in Lube? You know, they were having that conversation, so I just pay attention. Sometimes I try not to interrupt sibling argument and discussion. By the end of the day, I give a balance to the conversation. So those are franchise elements. So we begin to look at, is this a franchise deal? Are they licensed? Are they assigned? Those are pointers. If there is an assignment, if there is a license, like the last class, we use the book, for instance. I said in an intangible book, whereby it is a book, I, as the author of the book, the rights still reserves in me. I can then choose to give you license to adapt the book into a movie and be getting royalties. I can also give another person rights to transcribe to Hausa language and getting royalties. I give to somebody from the East to transcribe to Igbo language. I'm getting royalties. I go to France, if somebody transcribes to another language in French, and it keeps going like that. So one book can be transcribed maybe into 20 different languages. I am still the author of the book. Authorship hasn't left me, if you understand me. The real book, I remain the author. I'm signing with you to transcribe. The ownership of that right is simply saying that you are going to be paying me every year, maybe 1 million naira, 2 million naira for using my book. I am the original author. That's why when you see some movies, they put the name of the author of the book, right? But the ownership has now moved to whoever who translated the book into the movie. So they still remain the author of the original work. But in a situation where it's transcribed, most of the time, the authorship in the transcription too becomes dicey. Who retains the authorship? Should it be the original? Of course, I created the book initially. But work of transformation has come in. And when you transform, according to the new copyright law, whoever transformed the authorship pass to the person. So whereas you are the author of the English version of the book, you may not necessarily now be the author of the French version, but you'll still be acknowledged. And then you're also getting royalty. I hope it's a balanced conversation, guys. So that's some of the things you see. And that's what determines where the value is going to. Is it a franchise, is it royalties? That's how you trace it. So you might see in one copyrighted book, you see like different drawings. Those are sources of income, depending on what you decide to do with it. So if a lawyer is not equipped with this knowledge, this woman said she has created so many things. Part of what she has created, a book. She has written a book. Are you equipped enough to know that you are not just going to go and take up copyright protection? Remember, copyright does not even need to be registered, but it's desirable for us to deposit it because the prima facie proof that she's the owner of the work, right? That's on the one part. So what are the other things you do with a book? I just explained. It is a book like in the case of this woman. You begin to think, oh, this book is good. Oh. Nigerian universities will like it, or schools in Ghana will like it. So, but they need to change some scenario. That is when you now come in as an IP lawyer to discuss and open your client's eyes to seeing the different trees or branches of a tree. The book is a tree. Branches are now royalties. Incomes can come in from here, and there. So it is your responsibility to point them to all of these income, sources of income. Otherwise, they will not be able to reap the fruit of their labor. And for some people, they sleep on their rights, or somebody comes to them to sign off due for transcription, and because you have not earlier on told them this is what you expect, royalty, they just make a one-time payment because they are not knowledgeable in that space. So let's go on again. We look at now protection. This is the last case. Haven't looked at who, what, when, the value that has been created. And we are talking about where does ownership lie. The last case is now protection. So each time somebody walks into the office, for all these many scenarios, don't start looking for, I can see trademark, I can see patents, I can see industrial design. No, you must first break it down. Is it an ordinary idea? What is your business in basically have not created? How can you say somebody stole your work? Oh, you have created, you have a book, you have a brand, in a book that can see copyright. You have and in this your book, another thing you should know about a book, you don't just run up with somebody created a book. You also want to read that book. What were mentioned in the book? Did she mention a popular figure? Did she say something about somebody that is false? So IP is just all over. So it's not just about there's a book, let's go and do copyrights. You want to also look deep. What and what has been mentioned in the book? Can we say it's seen affairs? Can we say it's a fair use? Can we say that she got permission? Can we say she got clearance? So those are terminologies you need to also. But that's not for today's class, so we run again. And so when we look at protection, she said she has a business name. Let me see your contribution. If someone has a business name, what should we be looking at? What kind of protection should we get for the person? She has a business name, she has a logo, she has an app. So let's talk about the kind of protection you and I should be suggesting to these our clients. Anybody? You can just type, you don't have to unmute. Let's see your contribution. If someone walks into your office and say they have the business deal for you, they want you to take up some CAC registration. Remember I said when you contribute, it opens my mind to something else, right? This really works for me. But my brain is adjusting to the fact that maybe not too many of us understand this terrain yet. So I'm trying to strike the balance. But on a good day, I need you to pull it out. That's your contribution to knowledge. And so if you get a deal to register somebody's business name, so let me rephrase my question. Where do you begin from? Or what kind of advice would you give to your client? So if you're on this call, you've ever gotten a brief or a CAC, please say yes or no. Yes or no. I want to see the charts. Yes, everybody here. you dig it out by yourself. You have the next thing to now do. If you have identified that you got a business name, what else do you now do? Do you just run up to do the CAC? What else should you do for your clients? What kind of conversation should you be having if you have a CAC deal? That may be the first brief you get tomorrow morning. What should we do with a CAC brief? How do you treat a CAC brief? Guys, in one CAC brief, no matter what, even if it's a business name, the smallest kind of business name, please, that business name must get a trade different from the product she says she has, different from the logo she claims she has. So the business name may actually be a service business. So you already know that this business name, I'm going to register it as a trademark. Depending on the kind of business, you determine the class in which you register the person. By the way, for those who don't know, trademark is in classes. There are 45 classes. It is called NICE or NICE, N-I-C-E. That's the spelling, but I believe it's a French word. So it's called NICE classification of goods. So the first 1 to 34 has to do with products. So like she tells us that she has some products, you'll be thinking that course that's 1 to 34, depending on the kind of product. Like she tells us that maybe if she tells us she has a service business, DVIPC Academy is a service business. Now, DVIPC Academy is also a platform that connects creatives with maybe experts that can guide them on what to do in order to perfect for registration of one particular IP or not. DVIPC is also a product business, knowing that DVIPC Academy has about 2 books that it has created for sale. So if you understand the scenario I just painted now, it simply means DVIPC is a service business, DVIPC is a product business, DVIPC is a platform business. So these are the kind of 3 kinds of businesses. And if you look at this digital age, most businesses are going online, making them a platform business or a digital business, you know what I mean? And so it's no longer about a physical store. It's not about also protecting their interests online. So if this woman says she has a business thing, the next question again is, do you have online visibility? Are you just operating a physical store? Do you intend to go online in the next 10, 20 years? You need to get that information, which means even if doing business, you need to protect the person online. Maybe they're doing all this online consultation. You know, there are clinics or medical experts now that consult online, yeah? And so you need to protect the person online space. You need to protect the person in that particular class that deals with medical practice, right? You need to protect the person, perhaps the product she claims she has to do with some pharmaceutical products or medical machines or laboratory tools. You need to protect that person in all of those classes. Or that person has a skincare that has pharmaceutical elements and at the same time cosmetics, yeah, because skincare products naturally follow the cosmetics, which is perhaps class 3, and then you have pharmaceutical elements in all those skincare that deals with maybe ants and all those wishy skin infection, right? So it's no longer just cosmetics brand, it's now also a pharmaceutical brand. So you're looking at protection under class 3 and protection under class 5. That's not for today's class. In another of our class, we'll talk about how to understand police classification, how to break it down so that you can run with client instructions. So we said which IP applies. So for the brand name, I've discussed for across board, but to protect her online, to protect her not just at TOC, but to protect the brand name itself. Now she mentioned she has logo. Logo is also an element for trademark protection because of our time. So that's also where we can also put logo. Sometimes logo can also fall under copyright. It all depends on what the person intends or what the person who created it. If it's an artist that created that logo, originally created by an artist, even if it's a work of commission, you may first need to protect under copyright. Yeah, like I said before, copyright does not need registration. So far it is fixed in the medium. So far it is fixed in a tangible, medium, you can see it, whether it is transient or permanent. Copyright has been created and no one can take that away. And copyright will always lie in the author, except the person that assigns. And when the person assigns, authorship cannot be alienated. Guys, there's a lot to learn. IP is just everywhere. Authorship cannot be alienated. Even if it's a land, you sell your land, it's no longer on you. You no longer own anything on it. But if it is an intangible property, like we have discussed, we've used books severally as an example. Authorship remains, it doesn't go anywhere, it doesn't travel. Even after the right has lapsed, you remain the author. Authorship means you always be acknowledged. Even after, how come you think when people play song, they say acknowledge people like Michael Jackson, who is already dead? Because he remains the author of the work. But in case you have sold that work, he remains the author. People go every year, they send their people to go and learn and unlearn, then come back home and bring that technology, bring that know-how. So there was time that China and Asian countries were not creating so many things. So what they did was to send their citizens, sponsor them, you go to university there, you go here, attach them to different places. And after they learned, they brought this information home and started building China, Japan, and other Asian countries. And so they are now exporting. So the other countries they learned from are now upset. We took our market away. But not be by that. Are we this smart? And so imagine our brothers in Aba, they could go, bring in those knowledge, and come and create our own Aba made. The question is, could you and I patronize them? Because we have issues too. Even if they go and bring us Aba made, just like they have China made, and they put Aba here and put China, and you can barely tell the difference, only that this one is made in Aba, this one is made in China. Will you trust your brothers made in Aba? That's a question because Nigeria has issues. That's another intellectual property issue. We don't appreciate what we own, and IP is about our own. So there are different types of IP. There are communal intellectual property rights. That's where they're going to discuss the general kind of IP that belongs to the people as a general concept, and no longer to one person. So, but let's run. Is it copyright? To find copyright in this woman's book. Is it industrial design? She said she has some package design. So those who follow that industrial design here on my table. And so this fan has elements of industrial design. Like if you go to the market, you see other fans that all these curvy parts may not be curvy, might just be straight. Some other people, theirs might go this way, horizontal, vertical, diagonal. This one is curvy all the way. Even the blade inside, it has curvy shape. And the blade, from what I can count, 1, 2, 3, 4, 5, has 5. If you see another, I think this is long-term product. If you see maybe Philip product, you notice that the blade might be 3 inside. It may also be curvy. They have now differentiated their own design. Say their own is 3 blades inside. And the curvy part may not be curvy all the way. It might be a little bit shaped differently. So those are elements of industrial design. And industrial design is part of elements of branding. So branding is not just about trademark. It's a combination of both trademark and industrial design, especially when it has to do with tangible products like this. Now, the same plan has elements for trademark long tall. That is the name. This is their trademark long tall. And then this design that I've just described to us, those are elements for industrial design protection. Now, imagine this long tall. Of course, obviously, they made this fan. You know, before now, we didn't have fans as small as this. Maybe in the last 5 or more years ago, we didn't have all these fans that some celebrities are just walking on the road and carrying fan about like they fell from, I don't know if it's hellfire, the hotness there is not too much. So everybody needs to be walking about. There were days we didn't have this, so we don't need to overblow these exaggerations. And so this person now talks to him or herself. The sun is too hot, you know, so you need to design something that celebrities can walk about, or the bride during a wedding can hold and just be fanning herself. You know, the fan will just be going sort of doing the hand like this, like that. And so the person thought of designing something like this. And so you see, it's a form of innovation. Was fan existing before? The answer is yes. Were we able to carry those fans about? No, because they're kind of heavy, right? And so they depend on, to have this electrical wire attached to them. So the question is, when you're walking on the road, where will you plug that cable, right? So this fan is like an innovation, stepping it down into the space where it is needed. We can now all carry this about. We can now all move about with this. You can travel with this. You couldn't travel with the fan in your bedroom as a student. But sure, if you had something like this before you finished school, I'm sure you took it home because it's carryable. It's easy to carry. You guys get the gist, right? So when you have an existing technology step down or step up, you can have that under patent as well, protection. It means incremental value. So patent is not just for noble things. Remember, there's no law that protects trade secrets. Just let your client do what, shut up your mouth, keep it quiet. You don't, and then you have the client build safety guard around that trade secret. Have the non-disclosure agreements and confidential agreements, so that if she wants to employ people, right, she knows how to employ people and not disclose the information. I give the example of Coca-Cola. It is said they have been there for like hundreds of years now, okay? And then there was a time Coca-Cola wanted to go to India. And India had a policy then, like I told you before, Asians, there was a time Asians insisted on people going outside and bringing the knowledge home. Or the other version of this was this: if you come into our country, you must disclose. You must tell us what is inside your technology. So people are the ones now pushing down technologies on us, making us import into our country and suffocating our what industry. You get the gist? If Nigeria can do that, wow, I love it. Travels to India, I think it was in the 1950s or so. And so when they got there was that policy that says they're going to employ Indians in their factory and they must disclose. They must put them in position of authority where they know whether it is water and black gin or yellow gin or what are you mixing as your formula to get us Coca-Cola. You know that kind of gist bar. What did Coca-Cola do? They carried their bag, they pledged and came back. Someone has also told me that Coca-Cola started from here. I've heard all sorts of gist about Coca-Cola because at the time I was really digging deep into it and all that to understand what it did. And so part of what the Coca-Cola also did was to make sure it is said that the people that have the Coca-Cola recipe, maybe this person has formula, maybe the formula is divided into 4, right? And so I have Formula 1. And then the person on the call, Ima, has Formula 2. Then Muhammad has Formula 3. Are you guys getting it? Then Deborah has Formula 4. It is said that both I, Emmanuel, Muhammad, and Deborah, we don't know ourselves. We never met. We can never meet. Anytime they're having meetings, they don't put them on the same airplane. So that in case the airplane decides to go and crash, they will not lose all 4 of them. The 4 of them can never be in the same room to have a meeting. Are you guys getting the gist? So no one person holds that formula. This person has some part, this person has some part, and that is how they have been able to keep their secrets. So it's one of the things I discussed in my book, IP Adventure, whereby we saw a lot of that element of trade secrets, traditional knowledge, curated in a way that you still think you are reading just about trade secrets, but from trade secrets, you've entered geographical indications, traditional knowledge, and what have you, through storytelling, so that children can understand, creatives can understand, entrepreneurs, and it's such a beautiful story. So I hope you guys will see your hands on that book. So when we talk about protection, there's no protection for trade secrets. So you need to tell the person before you sign an agreement to bring a consultant to come and work in your firm, you must sign a non-disclosure agreement, and this is how long it's going to be and what that is how trade secrets are protected. So people will say trade secrets is not a form of intellectual property, but I belong to the school of thought that trade secrets is a form of intellectual property. Maybe one day we can have it as a debate. So the DVIPC Academy, we have an aspect in primary secondary school. So those are the ones who doing our debates for us, and maybe on such things we invite you guys to help us be the judge for such event. Here's my next slide, and this is where we now do hands-on class. I know we have not been participating for some of us. So looking at this next slide now, what can you see? We are now on IPs everywhere. The next slide, please. IP is everywhere. Can you spot intellectual property? Now, I know we're about, some people have left. I don't know if you can take data or whatever. So the issue is this. I need each of you to pick one intellectual property here. Pick one scenario from this slide. If you are picking restaurants, tell me the intellectual property you can see based on what we have discussed here this evening. If you are picking whether it's a church, like the school, so please pick one scenario and quickly type in the comment section. Please, I have hospital here. Yes, hospital. I see this. Just the names, chicken. Maybe it's a logo. I see trademark for logo. I see for name. Nobody should use hospital again because I'm using hospital as an example. So pick something else. Everybody please participate. Don't run away. Don't run away. This is how you know if you learned anything today's session. So in a hospital, I see this. Maybe they have a book. So this is it. Maybe they have a manual guide. I'm also giving you hints that will help you in other places. Maybe they have a particular, uniform. All those kind of things. I want to hear your thoughts on this. So pick one, and I want to see your shot. Or you can unmute and raise your hand so that you are unmuted and you can talk to us on the intellectual. Whether it's 1, 2, 3. If you don't see all of it, I'll help you bring out the rest. But if you're not going to participate, then I keep my mouth shut as well because I've come to the end of the class. So we have 2 minutes for this class. And which one are you picking? Is it a church, music studio? Yes, Lucy. Let's talk to Lucy. Can you unmute? Lucy, yes. Thank you,
Good
Lucy.
evening. Good evening, ma. Good
there.
evening, everyone. Okay, for restaurant,
Yeah.
for restaurants, I think the IP there would be trade secrets when it gets to recipes. If the
Wow.
restaurant is known for a particular type of recipe that is attracting customers, so
Wow.
it's important to have a trade secret there, have an NDA with those working for the restaurant,
Yeah.
because that's really the selling point of the restaurant, so it should be protected.
I agree with you. So what else do you see? Is that all? Lucy, is that all?
Definitely the restaurant will have a name. So that name should be trademarked, and there should be a logo associated with it when people buy things and they package the things for them in a nylon bag or whatever they use to package. At least the logo of the restaurant, the name of the restaurant should be there, and it should be trademarked.
That's beautiful. What else can you see? Is that all? I think you've tried. You've done an amazing work. So, what menu they have on the list, right? Lucy, you need to complete your task. Can you unmute again, Lucy? Because I'm reminding you now. So that's how you think, yeah?
Okay.
So they're going to have like, they give you the menu list, right?
Yes.
How about that? What will you do with it? Remember, these are businesses that come to you this week or maybe next week. You need to be ready. What will you do with the menu? How will you protect it? I will talk about books and copyright, right? Books and copyright.
Yes.
Yes, you can also look at it from the angle of class 16 that has to do with paper products or that trademark, right? So you need to be open-minded about some of those things. They also have what we call trade dress. Haven't you noticed some restaurants will have that, whether it's apron or whatever they put on top? Some they have t-shirts.
Yes, ma'am.
Like this my DVIPC. You understand, right? Trade dress. How will you protect their trade dress?
Because of how I think there is dynamism in life. If you say copyright your, this is food. I think the food is something that is general, kind of generic, kind of. So I would think that you have a menu and all the food there, all the food there. I think that will you say
restaurants that have curated their menu, like you said, the first thing you said was trade secret, remember? So when it is trade secret, maybe there's a special formula you use to put a particular thing. And so you have also tweaked the name and the presentation thereof. And so that's what you have put in the menu. You get the point? So it's different from Mama Ajobi's kind of menu and presentation thereof. You get the point? Was powerful. Thank you for your yes, Mohammed, please. The floor is yours.
Music studio. So you'll have copyright of their composition as well as their sound recording. That is master.
Okay.
And then they can trademark their logo and name of the studio.
This may not necessarily be a form of protection, but there are other things that will go in there, like performance rights, right? There are music studios, and I wanted to hear some like contracts, because sometimes, remember I said there is that conflict of law, sometimes it's not a conflict. but the meeting point of law, right? You may not necessarily use just copyright to protect other music studio. You need law contracts here. You get the gist? The contract between a performer, the record label, right? Are you getting the gist?
Yes, ma'am.
So they do a lot of contracts
Yes,
in that industry. So you can't do much without contract. The number one thing apart from copyright, remember I said copyright once it's fixed in the medium, you can even decide not to register, right? The number one thing they
of
work
course, ma'am.
with when it comes to the music is what's contract. So there's always contract between maybe the distributor and then the record label, or maybe
Yes,
we
ma'am.
have somebody else. Thank you so much, Mohammed. That was beautiful. Thank you. But it's mostly copyright. Copyright at the end of everything they produce in that place, it has copyright. Thank you, Mohammed.
The football club.
The what? Football. Wow,
The
that's another
football club.
fascinating. Yes, yes. You have the flow.
Yeah, for the football club, image rights is one
Okay.
of the IP issues
Mm-hmm.
in football.
Mm-hmm.
Then the logo of the football club, the
Okay.
jersey, the logo, then the mantra. I think
Mm-hmm.
so. The
Okay. Yes, the
mantra that has
mantra.
associated to
Yes,
the
yes, yes,
football
yes.
club. Yeah,
Mm-hmm.
yeah.
It's
Those
beautiful.
ones can be like marked. Yes, and if there are other
That's
ones
beautiful.
that
So,
you can also thank you.
okay. All right, so there are like endorsements, a lot of endorsement goes on there, just like in the music, you see a lot of contracts, you see a lot of endorsement deals here, you see a lot of sponsorship deals here, you see a lot of broadcasting deals here. Uh, and when it comes to broadcasting, you're looking at copyright, yes. And so, who owns the copyright when it comes to broadcasting? The broadcaster, right? And so that's why just now the World Cup we just concluded. You can't just do it anyhow. You have to have license to do it. You understand, guys? That's where the intellectual property is. And so it's one of the issues we find in copyright, whereby somebody has used broadcasting rights to exclude every other person from watching the movie. Remember the scenario I came to, that it's a fundamental principle of intellectual property, such that you can enjoy as a creator of the right, like the broadcaster. At the same time, the general public should be able to enjoy it. While we're growing up, we used to watch all these things on NTA. I doubt if they still watch all this football, what, on all these local channels. So you need to have maybe a TV or to go on YouTube to be able to follow a live show. It's totally unfair. And so we have some IP theorists who've been arguing this back and front to say there is no fairness. That rule has not touched on broadcasting rights, so when it comes to football, when it comes to these issues, sports events. So someone needs to touchlight that aspect. So please, next one. Thank you so much, Lucy. I appreciate that a lot. Okay, this is like our summer school events, like we said, DVIPC Academy. We are in there in primary school and secondary school. So we still drop this on your platform. We launched this today officially. And so this is to tell you, anyone that wants to go through, can we move the slide? Can we move the slide? So I'm going to be dropping this flyer on the platform. Because imagine if you learned intellectual property as a young child, as a teenager, what you'll be doing with intellectual property. For most of us who joined the call today, we didn't contribute simply because we knew little or nothing about intellectual property. And so this is where it comes from. Can we move the slide if possible? So we have a summer school event that's coming up starting from the 1st of August, hopefully, and it's going to run in batches, weekly but in batches for people in different parts of the world to be a part of it. If you really have a relation and wanting to learn about intellectual property, please help us spread this flyer and let them participate in it. I'll drop it as soon as I go out of this meeting. The next is Write the Adventure Storybook. That's one of my books. We also have a textbook. That has today. Thank you so much for being a part of this. Thank you for making it fun. I appreciate all your participation. Thank you, Lucy. Thank you, Mohammed. Thank you, Emmanuel, in the absence. Thank you, Deborah.
For the
And
session,
every other
do
person,
enjoy.
you know,
Have a pleasant
you're
night.
welcome. If you were not a part of last week, maybe I will share the link. I think we posted on maybe YouTube or Facebook. Please also follow us on social media and let us share whatever we post. So somebody sent something on our Facebook today. It was like this video, because on Fridays we try so as much as possible to take a video where we are creating awareness on one form of life. Every entrepreneur should see this. I'm like, well, we need partners who will be able to share some of our contents. So everyone needs to know about what the DVIPC Academy is about, what we're doing, and how to spread the gospel. And it's you and me and everyone out there that can help us to spread it. And to those who need information, get to know about it. So once again, thank you everyone. I'm Achindi, thank you for creating time. We want to